make sure that I've got. All right, I see both my judges, which is good. Ms. Riggs, is the plaintiff ready to proceed? Mr. Thompson, Mr. Cox, are the defendants ready to proceed?
Yes, Your Honor, we're ready to proceed.
Yes, Your Honor.
Yes, Your Honor, and my colleague Ben Simons will be calling the next witness for plaintiffs.
All right, before he does that, there was one thing that I meant to mention this morning that I neglected. Yesterday, during the introduction of lots of exhibits, the numbers themselves were referenced without any associated description as to each exhibit. The clerk in her record keeping needs both the number and a description of what the exhibit is. So when she keeps the court's notes in and when a lawyer in a courtroom introduces an exhibit, of course she would note the exhibit number, but she would also have a brief description of what that actual exhibit is. And rather than require the attorneys to go through what each exhibit is, I would like for each attorney to email to the clerk, Ms. Caitlin Bill, the description associated with the number for each exhibit. Do you understand what I'm saying?
I do, Your Honor. We'll work with legislative defendants and defendants to ensure we can arrive at an agreed upon description.
Okay. And so some of those descriptions might be apparent from the record when you introduced an exhibit yesterday during your examination. For example, the clerk, I imagine, was able to get a description of some of those, maybe not all of them, but rather than have you call those out, I think it's better that you just email the descriptions. That way she might be able to cut and paste it into her notes and so forth.
Thank you, Your Honor.
All right. Mr. Simon, you may call the plaintiff's next witness.
Thank you, Your Honor. The plaintiffs call Dr. James Lutus to the stand.
All right. Is Dr. Lutus here?
Dr. Lutus is not currently in the lobby.
I apologize for that. He has the link to join the lobby. I can confer with him about whether he's able to access.
And he was in the lobby earlier.
That is correct. I let the main attorneys know that he was in the lobby and waiting earlier.
Okay. With the court's indulgence, I will contact him.
Ms. Myers, I had put this in an email to you, but our previous witness had said she got kicked out of the waiting room after being in there for a certain amount of time without being admitted into the main courtroom.
Okay, there may be a timeout feature that, which we are not aware, but I can try to find out what that is. It may be that counsel just need to let witnesses know if they get timed out to, just sort of keep trying.
And Dr. Lutus should be in the waiting room now.
Not yet.
Mrs. Myers, I contacted Dr. Lutus and he says he replied that he's in the meeting now, or at least appears to be. Would it be beneficial to ask him to log out and rejoin?
Let's see if he's in the list. Yeah, it may be because there's only one person waiting right now in the lobby, and it's not Dr. Lutus.
Thank you, Ms. Myers. I contacted Dr. Lutus and asked him to log out of the link and rejoin,
Yeah.
and hopefully that
And
will clear
he
the
is-
issue up.
I was just about, okay, he's in.
Great. The plaintiffs call Dr. James Lutus to the stand.
Dr. Lutus, are you able to hear me?
Oops.
I see
There
you
we go.
now.
Can you hear me?
Dr. Lutus, are you able to hear me?
Yes.
All right, if you would please raise your right hand. Madam Clerk, if you could please swear in the witness. Well, I don't see Ms. Beal chiming in, so Dr. Lutus, do you swear that the testimony you are about to give this court is the truth, the whole truth, and nothing but the truth, this your solemn affirmation?
Yes, I do.
Mr. Simons, you may examine the witness.
Thank you, Your Honor. Good morning, Dr. Lutus.
Good morning.
Could you please introduce yourself to the court?
My name is James Lutus. I'm professor of history at the University of North Carolina at Chapel Hill. I've held that faculty appointment since 1989.
What is your educational background?
I earned an undergraduate degree in American history from the University of North Carolina at Chapel Hill in 1977, an MA in American history from Northwestern University in 1979, and a PhD in American history from the University of North Carolina at Chapel Hill in 1989, and at that time joined the faculty.
What subjects do you specialize in?
My research and teaching have focused broadly on the political and social history of North Carolina from the time of the Civil War to the present day. In the last decade, or a little longer than that, my primary interest and focus has been on questions of race, poverty, and voting rights.
Have you published any books?
I have 4 published books, all from the University of North Carolina Press.
Is one of those books titled Fragile Democracy?
Yes, it is.
When did you write this book?
This book appeared in print in September 2020. It comes out of a long research project, as I've suggested, that dates back to 2006, 2007, when for a prior book I first began working on issues of poverty, race, and voting rights.
Have you received any professional awards for your scholarship?
I've received a number of awards and prizes, including prizes from the leading professional organizations in my discipline, the American Historical Association and the Organization of American Historians.
Have you ever served as an expert witness?
I have. I served as an expert witness in state conference of the NAACP versus McCrory, the House Bill 589 case that made its way eventually to the Fourth Circuit. And I was retained as an expert witness in a voting rights case in Jones County, North Carolina, but did not submit a report because that case was settled out of court before the issue went to trial.
Are you currently serving as an expert witness in any other cases besides this one?
I am. I'm also an expert witness for the plaintiffs, the state chapter of the NAACP versus Cooper, the case involving Senate Bill 824 that's currently pending in U.S. District Court for the Middle District in North Carolina.
Your Honors, I'd like to move to admit Professor Lutus as an expert in North Carolina history, politics, government, and public policy under North Carolina Rule of Evidence 702.
Is there any objection?
Your Honor, I'd like to conduct a brief voir dire, if I may.
Your Honors, plaintiffs have no objection to a brief voir dire on Professor Lutus's qualifications related to the subjects on which he is offered as an expert, but plaintiffs will object if opposing counsel's questions cross over into cross-examination questions on the scope of his opinion.
Well, Mr. Thompson, I'll allow you to conduct a brief voir dire, but I will say this is the second time the plaintiffs have attempted to tender a witness as an expert witness, and this is the second time that you've attempted to challenge that by a brief voir dire. And so I would rather for you to state perhaps the grounds upon which you intend to question him about his qualifications and about the tender that the plaintiff just went through before you examine him on voir dire.
Yes, Your Honor, I'd be happy to do so. He's just been tendered as an expert on public policy, and that's a very broad, amorphous topic. His report talks about, for example, charter schools, and he testified that he's not an expert on modern education policy. So it goes to the fact of his expertise. And when they say he's an expert on public policy, that is so broad, I think it would respectfully suggest that it should be clarified where the contours of that are. If the court would prefer me to do this during cross, I'm happy to do it. We have no objection on his being certified as a historian. He is an expert historian.
I would prefer that you do that on cross.
I'm happy to do that. Yes.
These questions and with each expert try to voir dire them to narrow their scope. If you think he's testifying outside the scope of his expertise, if he is outside the area that you feel like he has expertise in, then of course object. State the grounds for that objection, and we'll then hear it at that point.
I'll be happy to proceed in that fashion. Thank you, Your Honor.
All right, thank you. The witness is received as an expert within the fields for which he was tendered. Mr. Simons, you may ask the witness his next question.
Thank you, Your Honor. Professor Lutus, on what issues were you asked to opine in this case?
I was engaged by the plaintiffs to prepare an expert report on the broad history of race and politics, race and voting rights in North Carolina, from the time of the Civil War to the current day, and to evaluate the place of Senate Bill 824 in that history, to place that piece of legislation in the context of that long period of historical development.
How many reports did you prepare in this case?
Two, my expert witness report and a rebuttal to Professor Callanan's report.
Did you review any primary sources in preparing your reports?
A wide range of sources, archival collections of the personal and private papers of figures who were key players in this story, session laws of North Carolina, court cases, of course, various reports published by state and federal agencies, as well as those published by an array of advocacy organizations on all sides of this issue, and period newspapers.
Did you review any secondary sources in preparing your reports?
I did. A wide range of scholarly works, books, articles, theses, and so on.
How did you choose the sources that you cited in your reports?
Really standard practice in my discipline. I think anyone peer reviewing my work would expect the sources that I've enumerated. So in that sense, really following the standards of the profession.
What conclusions did you reach in your initial report?
that North Carolina has a long and cyclical history of voter suppression through measures that have appeared on their face to be race neutral, but in their actual implementation have proved to be profoundly discriminatory against minority voters, particularly African Americans. I think if we look back over the last 150 years or so, we can see a repeating pattern, repeating episodes in which there was expansion of minority access to the ballot box and also expansion of minority representation in government, answered in each instance by legislation that in a variety of ways I've detailed in my report have worked in practice, though they seemed on their face racially neutral, worked in practice to suppress the black vote and limit black political participation. And it seems to me, considering that long history and the particulars of the history and particulars of Senate Bill 824, that legislation fits squarely in that large overarching pattern.
Dr. Lutus, to what did your rebuttal report respond?
I responded to Professor Callanan, who contended that the provisions in SB 824 for a wide variety of photo IDs, the provision for declaration of reasonable impediment, he contended that these made the law quite generous in its accommodation of voters. My argument in response to that is that while that may seem to be the case on the face of the law, upon close examination, it seems clear that it has the potential, as other legislation before it, to seriously compromise the voting rights of minority citizens.
Dr. Lutus, are your reports complete?
They are.
Do they accurately disclose the opinions and testimony that you are offering in this case?
They do.
Your Honors, I'd like to move to admit both Professor Lutus's initial report, which is marked JX0695, and his rebuttal report, which is marked as JX0696, into evidence, and also as Professor Lutus's direct testimony in accordance with the party's stipulation on expert witnesses.
There's no objection, Your Honor, from the legislative defendants.
No objection from us.
Those exhibits are received. Thank you. You may proceed.
Thank you. Professor Lutus, did you observe any patterns after analyzing the history of voting and election laws in North Carolina?
Well, that pattern, as I said, of repeating episodes of expanded minority political participation answered in relatively short order in every instance by measures that appear on their face racially neutral, but have had the effect of being racially discriminatory. I think we can divide this chronology, this 150-year period of time that I've examined, into three broad episodes. The first is from the end of the Civil War, from emancipation to black disenfranchisement at the end of the 19th century, beginning of the 20th. I would describe that as the long era of Reconstruction. The second period runs from disenfranchisement to passage of the Voting Rights Act in 1965. This is the period we conventionally think of as the era of Jim Crow. And the third period begins with the Voting Rights Act in 1965 and extends to the modern day. It's the episode that we're living in this moment.
Dr. Lutus, is partisanship a characteristic of the pattern you've observed?
This I think is such an important fundamental question and issue. Party labels, partisan labels are useful to us, I think, to the extent that they help us keep track of the players on the field. It's a bit like being at a sporting event and having the team rosters in your lap. You know who the players are and you can begin to understand what they're doing. But beyond that, thinking about these sort of issues in partisan terms can be misleading. In fact, a focus just on partisanship can obscure much more than it reveals. I mean, I think we have to remember that party alignments on issues of voting rights have changed dramatically over time. The Democrats of today are not the Democrats of the past. The Republicans of the past are not the Republicans of the day. So there's been a lot of change and party realignment over time on these issues. But throughout all of that, and this is where it seems to me we want to keep our focus, not on who's in what party, but two things that have remained constant throughout this 150-year period. The first is the question of whether every citizen has a right to cast a ballot in a free and fair election, and including minority citizens. And if so, how is that right best safeguarded, and under what conditions and circumstances is it to be exercised? I mean, that's been the issue since the ratification of the 14th and 15th Amendments to the U.S. Constitution. And then second, I think it's really important for us to, again, remember the pattern in each of these episodes. When minority citizens have gained political power, they've gained increased access to the ballot box, increased political representation. When they have done that, again and again, the party in power has moved to constrain that political participation, moved in ways that effectively constrain that political participation, particularly when those minority voters, because of the way they voted, posed a challenge to the governing party at the time.
Dr. Lutus, the first instance of the historical pattern that you've described runs roughly from the end of the Civil War through the end of the 19th century. Is that correct?
That's right.
What was the most significant law from that time period passed to restrict African American voters' access to the ballot?
Yeah, well, to answer that question, let me sort of bookend the period for you. It really begins in North Carolina and with the North Carolina Constitution of 1868, which guaranteed all adult men the right to vote and guaranteed every adult male citizen the right to cast their ballot in a free and fair election. So that's the bookend right after the Civil War. And then if we go forward 35 years, there's a long struggle over race and voting rights that culminates in the late 1890s with a virulent white supremacy campaign, and then with ratification of an amendment to the state constitution in 1900 that required passage of a literacy test and payment of a poll tax as preconditions for registering to vote. And then in 1901, legislation that implemented that constitutional mandate.
What was the effect of the literacy test on African American political participation in North Carolina?
Well, in a phrase, it's wholesale disenfranchisement. Very, very few Black citizens managed to register to vote. For all intents and purposes, Black North Carolinians were, as I say, at a kind of wholesale scale, removed from the political life of the state.
Dr. Lutus, the second instance of the historical pattern that you've described runs roughly from after the passage of the literacy test through the enactment of the Voting Rights Act, correct?
That's correct.
Despite the effects of the literacy test, did African American candidates enjoy any success in North Carolina during this time?
They did some, but it was hard won. What characterized this period at the outset, particularly in the years before World War II, was a persistent and determined effort to mobilize residents of Black communities to present themselves to the literacy test again and again and again, in effect to challenge the literacy test. Now, that only began to gain some meaningful traction in the years after the Second World War, um, primarily because of the organizational efforts of labor unions, of the NAACP, and in particular within the NAACP, the involvement of Black veterans returning home from World War II. So that by the mid 1950s, roughly a dozen Black officials were elected in North Carolina, uh, all of them at the municipal and county level in the eastern part of the state, where historically North Carolina's Black population has been concentrated.
Did the General Assembly respond to these victories by African American candidates?
Yes, they did, in a variety of ways, and I've detailed these in the report. But they did things like move from ward to at-large systems of municipal and county government, implemented multi-member districts in the legislature, put in place numbered seat plans for legislative offices, and also passed a prohibition on single-shot voting. So what I think is interesting here is that all these measures were sort of narrowly drawn and targeted. They were in that sense sort of tactical. They didn't apply for at-large representation. It didn't apply to every municipality and county in the state. Um, Same thing with legislative districts. Those measures are put in place with very few exceptions in the East, again, where a Black population had been concentrated. And I think, the point about the single shot prohibition, I mean, it's important to pause here and just to understand clearly, what that was about. I mean, this was a very clear instance of lawmakers making a claim to alleged election fraud um, in the form of what they described as Negro block voting. That is, Black voters in a coordinated way voting shared interest on election day. The argument was that that constituted election fraud. And once that claim to fraud was established, it became a pretext for putting in place an election regulation that, again, on its face, race neutral, but had the effect of disadvantaging minority citizens.
Were all of the measures that you've just mentioned, changes to election laws, were they all passed in a single piece of legislation?
No, they were not. And, that's a bit of what I meant in that explanation, but they are passed piecemeal. Even with the change from ward to at-large systems of representation, that wasn't done for multiple locations at once, but most often by focusing on a particular county or municipality one by one by one.
What were the effect of these changes, Professor Lutus?
Well, and the one thing I'd add there is that that kind of tactical approach was also very effective at helping those measures evade judicial scrutiny, precisely because they were not done on a wholesale scale. The effect basically put a stop to the election of Black candidates at the municipal and county level. And I think a single number really tells the story of the broad effect. As late as 1971, 6 years after the Voting Rights Act, there were only 2 Black lawmakers in North Carolina's General Assembly.
Dr. Lutus, the third instance of the pattern that you've described in your reports runs roughly from after the enactment of the Voting Rights Act through the present day. Is that correct?
That's correct.
Were African Americans able to increase their representation in the North Carolina General Assembly during this time?
They were. And the important thing, I think, to recognize here is that the change came not by voluntary action from the legislature, but what characterized the first 2 decades of this period was judicial intervention. judicial decisions to enforce the Voting Rights Act, decisions that compel the legislature to take down many of those barriers that had been erected in the 1950s and 60s. Once that was done, that work in a way was some degree complete with Jingles in the mid-1980s. Once that was done, change was quite dramatic. So by 1991, there were 19 Black members of the General Assembly, and that, of course, is the year in which Dan Blue was elected Speaker of the House of Representatives. So quite dramatic change as a result of judicial intervention.
What was the effect of the increased number of African American members of the General Assembly?
Right. Well, the new General Assembly in the 1990s and 2000s passed into law a number of measures designed to increase citizens' access to the ballot box. So the introduction of early voting, out of precinct voting, same-day registration, and a pre-registration program for 16 and 17-year-old teens who, when they got their driver's license, they were pre-registered to vote, so that when they turned 18, they would be prepared to cast a ballot.
What was the effect of these new laws that you just described?
A dramatic increase in Black political participation, and you could see that in a couple of figures. By the end of the first decade of this century, new Black voter registration had increased 50%, quite a dramatic figure. The comparable or point of comparison in the same period for whites was an increase of about 16% in registration. And in terms of turnout, we saw Black turnout go from a kind of benchmark low at the beginning of this period of, I think the figure is 40%, maybe precisely 42%. By 2008, turnout of minority voters has risen to 72%. So dramatic changes once these new measures were put in place.
Dr. Lutus, are you familiar with the law known as House Bill 589?
I am.
What is that law?
It was an omnibus bill passed in 2013, literally on the heels of the Supreme Court's Shelby decision. And I say an omnibus bill because it targeted all of those accommodations I just listed. And each of those accommodations, we know from election data, were used more frequently by African American voters than by white voters. So House Bill 589 shortened the period for early voting, did away with same-day registration, did away with out-of-precinct provisional voting, did away with the pre-teen registration or the teen pre-registration program. And most importantly, for the purposes of this conversation, imposed for the first time in North Carolina law a voter photo ID requirement. And as I said, each of these measures targeted accommodations used more often by African American voters. And the same is true sort of in reverse with the photo ID. For example, at the time, Black percentage of the state's population is around 22%, but Black North Carolinians represented not quite a third of all the adult citizens without an acceptable form of photo ID under the terms of House Bill 589.
As it was written, did House Bill 589 explicitly target African Americans?
No, it said nothing explicit about race.
How does House Bill 589 compare with previous laws in North Carolina that you reviewed?
Really the important characteristic is that omnibus approach of targeting all these measures at once, which is a real change from the kind of more tactical approach that I described in the middle period.
Did the omnibus and tactical pieces of legislation that you've described share a goal?
They certainly shared an effect, and that was to limit minority political participation. That is common as an effect for all these pieces of legislation.
Are you aware of what happened to House Bill 589?
It was ultimately rejected by the Fourth Circuit Court of Appeals. And it was rejected. The court referred to that omnibus approach. I think I have the words of the court right. The ruling was that law targeted African-American electors with near surgical precision.
Dr. Lutus, are you familiar with the law known as Senate Bill 824?
Yes, I am.
What is your understanding of what this law does?
It requires the presentation of voter photo ID in order to cast a ballot. It expands the range of acceptable forms of ID and also introduces provision for declaration of a reasonable impediment to acquiring said ID.
Dr. Lutus, in your opinion, does Senate Bill 824 fit within the historical pattern that you've described today?
I think it does. Again, it's a piece of legislation that on its face is race neutral. But I think when you put it in the historical context and sort of think through the legislation, it becomes clear that it has quite significant potential to discriminate, I guess, against the interest of Black citizens, against Black political participation.
So, based on your analysis in this case, do you have an opinion on whether African American voters will have more difficulty obtaining a photo ID under Senate Bill 824 than will other demographic groups?
I think they will, as a group, experience greater difficulty.
What is the basis for your opinion?
Well, in a word, poverty, which is arguably the most lasting consequence of North Carolina's Jim Crow past, and our nation's Jim Crow past, for that matter. I mean, sort of think through the situation. Black North Carolinians are far more likely to be impoverished. The poverty rate, today, about 22% of North Carolinians live in poverty, 9% of whites. So 2.5 more times likely to live in poverty. And that poses real problems. It means, for instance, that Black North Carolinians are more likely to be employed in low-wage jobs in which they can't afford or often are not allowed the time off from work to go and acquire an ID, particularly when the offices that provide those IDs are opened only during normal daytime business hours. Poverty also means, in ways I've detailed in my report and won't recite all of that here, means that Black voters are also significantly more likely than their white counterparts to have access to private transportation, to own a car. And the Black population, as I said earlier, a considerable part of it is concentrated in eastern North Carolina, where poverty is concentrated as well, a rural region where public transportation is limited at best, more often than not is non-existent. And so that really poses a huge burden, especially when we recognize that North Carolina DMV license plate agents, licensed driver's license agencies in that rural part of the state are fewer and further between than they are in the more built up urban areas of the state.
Dr. Lutus, what sources did you review to reach this conclusion?
I looked at census data on the demography of North Carolina and the demography of North Carolina's regions, census data on poverty rates, again, across the state and regionally, on publicly available DMV data on the location of driver's license agencies, data also on auto loan rates, insurance costs, and so on, those differentials by race.
Did you look at any materials on the locations of State Department of Motor Vehicles offices?
I did. I looked at data that's publicly available on the DMV website. Quite good maps there of those locations.
Dr. Lutus, I would like to bring up page 77 of your initial expert report.
Sure.
Okay. Dr. Lutus, in this paragraph, you refer to the phrase hardship exemptions. Is
Yes.
that correct?
Yes.
What is this a reference to?
It's a reference to the provision for declaring a reasonable impediment for not having photo ID.
What is your understanding of how the reasonable impediment declaration process works?
That on election day, an elector will have to attest to a reasonable impediment to a voting site official. Now, that seems straightforward, but it's a little more complicated than that. That voter has to know that he or she is entitled to claim this exemption. Process depends on the voter's request or the polling official's offer of the required form. The form needs to be filled out correctly and so on. And once all of that is done, the voter will cast a provisional ballot, not a regular ballot. And that ballot will be counted or not, depending on election officials' judgment of the legitimacy of the reasonable impediment declaration.
And just to confirm, the reasonable impediment declaration process that you've just described is available to voters who lack a qualifying form of photo ID?
Yes.
Dr. Lutus, are African Americans more likely to have to use the reasonable impediment declaration process?
Again, I think if we sort of walk ourselves through the process, I think what's concerning here, just to put a frame on this at the beginning, is that there is good reason, it seems to me, to be concerned that what Senate Bill 824 will do at the end of the day is create two classes of voters. A subset of Black voters, for the most part, who are set apart from other voters. And let me explain what I mean by that. Because Black voters are more likely to live in poverty, for reasons I've just explained, they're more likely not to have a qualifying form of ID, particularly driver's license, a non-operator's ID, or one of the free IDs available from the offices of county boards of elections. Since they're more likely to lack the required ID, they're more likely to need to declare a reasonable impediment. Now, when they do that, they open themselves to challenge the legitimacy of that claim and their entitlement to cast a ballot. And I think it's really important to bear in mind that beginning with changes made by House Bill 589 and preserved by Senate Bill 824, the likelihood of challenge is far greater than it had been in the past. It used to be that a challenger and a challengee had to be registered in the same precinct. But House Bill 589, Senate Bill 824, both make provisions for political parties to appoint at-large election monitors at both the county and the state level, who may go anywhere within a county, anywhere within the state, to pose a challenge. So we've sort of escalated the exposure to challenge for this subset of voters. And as I said, at the end of the day, they do all those things. They cast a provisional ballot. Election officials will make a judgment on that influence, one would assume, by any challenges that are raised by third parties. So as I said at the beginning, I think the worry here is that there's great potential to create two classes of citizens, one of which is subjected disproportionately to a test that other voters are far less likely to confront, if at all. There's a worrisome familiarity to that sort of situation.
Do you have any other concerns about the reasonable impediment declaration process?
Well, I wrote in my report about what I would describe as soft intimidation. And again, we can kind of think through the process, put ourselves in the shoes of another for a few minutes. Imagine a voter, the sort of person I've been describing, and it's election day. And I think it's not to ask too much to imagine that they might feel some trepidation. I'm going to a public place and I'm going to have to acknowledge my poverty to an election official. For most people, there's a bit of embarrassment there, but it escalates. That voter may well be wondering, how is this going to work? Am I going to be pulled out of line and sort of marked publicly as different, as a problem? Am I going to be challenged? And how is that going to work? And if I'm challenged, am I going to get in trouble for doing something I thought was perfectly acceptable? And then, of course, at the end of that, the question, is my vote going to count? I don't know. It's going to be evaluated by a process that I don't know much about or understand. I think it's not hard to imagine that some number of those voters are likely to decide just to stay home. And finally, this points to another aspect of North Carolina's history that I think it's really important to understand, and that is, across this 150-year period I've been describing, the most hotly contested elections have been decided by tiny, slim margins. Right? So the kind of lesson in that history is that to change an election outcome, you don't need to move lots of voters. You just need to move enough voters. And so again, I think there's just real potential here for, in effect, creating two classes of voters.
Dr. Lutus, are you aware that during the 2018 election campaign season, when prior to the vote on the voter ID constitutional amendment in North Carolina, that some North Carolina Republicans argued that voter ID laws were necessary to prevent voter fraud?
Yes, I'm aware of that, and indeed they did.
What is your opinion of this argument?
Well, again, I go back to this history that I've been recounting. I would have in mind the other instances in which a claim of widespread fraud was a pretext for passing measures that imposed a special burden on minority electors. Preventing fraud was one of the reasons given for imposing a literacy test. I've talked about the single shot prohibition. We can see multiple times when a claim to alleged fraud, in effect, is positioned as a pretext for the passage into law of measures that in practice have a profound discriminatory effect.
Professor Lutus, do you know if the North Carolina Constitution currently says anything about voter ID?
Well, it does now after the 2018 amendment.
So is it your understanding that absent the passage of another constitutional amendment, there will be some form of a voter ID requirement in North Carolina?
You know, I'm not a legal scholar, so I can't, you know, sit here today and offer a professional judgment on that. I think what I can say is a reasonably informed, I like to think, a layperson here in the moment thinking about that question would at least be willing to, you know, give you a 50-50 wager that some form of voter ID will eventually be required.
Is it your testimony here today that any voter ID law would fit into the historical patterns that you've described?
That's not my testimony at all. I'm not even sure, you know, what that word "all" means. I've certainly not examined every imaginable permutation of a voter photo ID requirement. What I would say in addition to that is that, again, I would come back to this pattern of measures that seem on their face race neutral, but in practice have a profound discriminatory effect. And I would want to be mindful of that history, particularly in this conversation, because, you know, as I said, it suggests that we need to move with great care, because what we're talking about at the end of the day is a fundamental, constitutionally protected right. That's about as basic as it gets in terms of the functioning of our democracy. So the history I've recounted, it certainly gives me reason to want to proceed with great care and caution.
In your analysis, did you consider the partisan affiliation of the legislators who supported Senate Bill 824?
Well, again, you know, to the degree I explained earlier, you have to use partisan party labels in order to identify the players. But as I said earlier, political party positions on these issues have changed over time. There have been realignments. So I would keep my eye on that fundamental question about voting rights. Yeah, I'm kind of repeating my earlier remarks, but I think we just need to be careful not to see it simply through that lens. It tends to hide more than it makes visible to us.
Okay. Professor Lutus, are you suggesting that supporters of Senate Bill 824 were racially prejudiced against African Americans?
No, I am not. I don't have the power to see in their hearts and minds and render that kind of judgment. Again, what I can say here today as a historian is that I see this long pattern over a period of more than a century and a half.
And can you describe this long pattern that you mentioned?
Right, so a long pattern in which we see these repeating episodes of increased Black political participation at the polling place, representation in government, answered in short order by measures that on their face are race neutral, but in their effect are profoundly discriminatory. And we especially see this when that increase in minority political participation poses a challenge to whatever party is in power. Again, a kind of quick response in the form of these ostensibly racial neutral measures that are profoundly discriminatory. And let me just sort of circle back just for a second to the question you asked about partisanship. I want to be very clear, what this means in the terms of the way I've written about this. If Democrats had passed the laws we're talking about in the current period, that would have been the plural noun in the narrative. But Republicans passed it. That is not a statement of anything innate about political parties. But again, it's simply about keeping up with the players on the field. What matters is this underlying pattern, which is a through line through the state's political history.
Thank you, Dr. Lutus. Your Honors, those are all the questions I have at this time.
Thank you. Cross-examination, Mr. Thompson.
Thank you, Your Honors, and good afternoon,
afternoon.
Professor. I'm David Thompson, and thanks for sitting here today for cross-examination. Let's start with some questions about historical analysis. Do you agree that primary sources are fundamental to historical research?
Certainly.
And that's where you start.
Doing historical scholarship is not a one step, 1, 2, 3 recipe. The way historians start their work is certainly with primary sources, but also with secondary sources. It's an iterative process, and the examination of those two kinds of sources go hand in hand. Historians start by examining the archival record, getting their own individual feel for the stories that are there, the stories that are not there. At the same time, you're looking at secondary literature and asking how have other historians understood this material? How do their explanations stack up against the documents? What new questions or discoveries might change our historical understanding? So it is an iterative kind of conversational process, not a recipe.
You can't support a conclusion without a primary source, correct?
I'm not sure that is a general rule across the profession because many conclusions are based on a review of secondary sources. One of the most important journals in the profession is something called Reviews in American History, which are extended reviews of secondary sources, which come to conclusions. But certainly in terms of unpacking the historical story I presented here, yes, primary sources are essential.
And what you're looking for as you're doing that kind of work is to try to assure that the conclusions you're drawing, the patterns they identify, accommodate and take into account a body of primary source material, correct?
Yes, that's correct.
In preparing your report, you did not review any other states' elections laws. Is that correct?
That's right, because I'm not a historian of every other state. I'm a historian of North Carolina, and my concern is with the particulars of this state's history.
And information about other states was not relevant to your analysis, correct?
I wouldn't say that it's irrelevant. Oftentimes, reading about other examples of what you're writing about might help to attune you to a question you'd not thought of. And I can give you an example. My second book was on the history of education. I learned a lot to think about a generation of historians, of education reformers in the late 19th century by reading the literature on people like them in Russia in the same period. Obviously, they weren't influenced by one another, but the kinds of questions my colleague was answering in that context were useful to me in examining the
Each
materials
state,
at hand.
sorry, go ahead.
No,
I'm sorry.
I'm finished.
I'm sorry, I didn't hear the end. I heard my colleague was answering.
Oh,
context
so
where-
the questions my colleague was asking, in a Russian context, were helpful to me in formulating analytical questions about the material I was examining.
Each state has its own history of dealing with the moral and civic crisis brought on by the mass mobilization for democratic rights and equal citizenship, correct?
Read that to me again.
Each state has its own history of dealing with the moral and civic crisis brought on by the mass mobilization for democratic rights and equal citizenship, correct?
Again, it doesn't seem to me that that's a yes/no question, because if the answer to that is yes, then there's no national history of any of this. And of course, all of these debates occur in a national context. Voting Rights Act of 1965, for example. But each state does have a particular history of dealing with the issues. Yes, but it's not solely particular or solely national. Again, these things are together.
Well, the quote I read you comes directly verbatim out of your report, so I'm a little surprised that it's not yes or no. Let's pull up page 45 of your report. And you see it says, well, we're going to make it a little bigger.
Yeah, there we go.
There we go. Each state has
my
its
aging
own
glasses, yeah.
Okay, there we go. Each state has its own history of dealing with the moral and civic crisis brought on by the mass mobilization for democratic rights and equal citizenship. You said it in your report and it was accurate, correct?
I said it, and it says, if you read that sentence in the context of the report, it says exactly what I just explained to you.
In
And
18,
excuse me, would you let me finish answering the question, please? What I am saying there is that, yes, there is a big national question of the consequences of emancipation and Black citizenship and Black voting rights. Now, each state does have its own history of dealing with that. The particulars in Mississippi are not exactly those of North Carolina, not exactly those in Virginia. And that's what this sentence says, if read in the context of the report.
in 1868, North Carolina voters gave the biracial Republican Party 6 of North Carolina's 7 congressional seats and control over more than 2/3 of the seats in the state legislature. Is that right?
What was the beginning of that?
In 1868, North
Gave,
Carolina.
gave Black voters control over.
I'll say it again, sir, if that would be helpful. In 1868, North Carolina voters gave the biracial Republican Party 6 of North Carolina's 7 congressional seats and control of more than 2/3 of the seats in the state legislature, correct?
Yes.
Okay, and the scale of the Republicans' victory reflected the fact that in North Carolina, the percentage of whites who crossed the color line and made common cause with former bondsmen was larger than in any other state, correct?
Any other southern state, yes. Any other former Confederate state.
And that's still true today. President Obama lost throughout the South, but he won in 2008 in North Carolina because of white crossover voting, correct?
Well, until he lost.
Well, in 2008.
But this is a really good question, because this is a point I was making earlier, and I think it's helpful to expand on it a little bit. It is the case that actually in Reconstruction, and again in the 1890s, in what was called the Fusion era, a larger percentage of white voters crossed the race line than the other southern states. And one might argue that if biracial politics had a chance in the late 19th century, it was here. Now that explains a lot of the history that I've been talking about, because in this state, even in this period, these victories were won by a very tiny margin, and so much of the effort was not to move every voter, but to use racial appeals and other tools to move just enough white voters out of that biracial alliance. It is why these issues have been historically so hotly contested in the state of North Carolina.
Are you saying that we need to look at these changes to voting rights based on the marginal impact on elections? I'm not sure about your point on the margin you just made.
No, I'm just saying that these issues have been hotly contested because of those small margins, and that interventions that might look limited in that political context have the potential and have had the demonstrable effect of making a profound difference in political participation, and in turn, as a consequence of political participation or political representation, in turn, a profound difference at the end of the day in voter participation.
In 2008, President Obama won North Carolina because there was more white crossover voting in North Carolina than in any other southern state. Isn't that right?
You know, I don't know that that's the case. What I do know is that he won by roughly 14,000 votes, and that number was pretty close to the number of Black voters added to the rolls.
At the margin.
Well, I mean, 14,000 vote win is a win on the margins.
Yeah. And that coalition of white crossover votes and African-American voters is why Governor Cooper has won the last two gubernatorial races, right?
You know, I haven't looked at the data, so I want to be careful about what I say here. I'm sure that's a pretty good bet.
Okay. In the late 19th century, North Carolina created the most democratic political system in the South. Is that right?
For a moment, yes.
And that was thanks to lawmakers from the Fusion Party. Is that right?
It wasn't a fusion party. It was a coalition between white populists and a biracial alliance in the Republican Party.
And they forged a political partnership and ran a historic joint slate of candidates. Is that right?
That's correct.
And on election day of 1894, the Fusion candidates won 116 out of 170 seats, a majority in the North Carolina legislature. Is that right?
That's right.
And on the local level, in 1894 and 1896, they also elected more than 1,000 Black officials. Is that right?
Roughly. That's a difficult number. That's one calculation, yeah.
Okay. Fusion legislators revised state election law with the aim of guaranteeing full and fair access to the franchise. Is that right?
Read that to me again.
Fusion legislators revised state election law with the aim of guaranteeing full and fair access to the franchise. Is that right?
Yes, I think you're referring to the election law of 1895.
Yes, sir. Among their reforms were provisions that ensured that neither travel nor lack of public notice would be an impediment to voting. Is that right?
That's correct.
Why was lack of public notice an issue?
Simply because it was a way of keeping people uninformed about opportunities to register and opportunities to vote.
And to safeguard impartiality in voter registration and the supervision of elections, the law gave clerks of the court, who were elected officials and therefore accountable to voters, the authority to appoint in every precinct one registrar and one election judge from each political party of the state. Is that right?
That's correct.
Was that bipartisan nature of those committees important? And if so, why?
You know, I've not examined the work of those committees, so it's very hard for me to say definitively. But yes, the point was to have fair supervision of the elections.
And having a bipartisan committee increases the odds of fair election of the administration of the elections, right?
In those circumstances, yes.
Okay. And the same is true of SB 824. You understand that in order for a reasonable impediment ballot to be invalidated, it has to be a unanimous decision of a 5-person bipartisan committee. Is that right?
Yes.
And that helps to promote fairness in the administration of the law, correct?
I suppose it might in some significant ways, but I don't think we can separate that from the rest of the law. The law you're referring to in 1895 did not allow roving at-large challenges.
What's your basis for saying there are roving at-large challenges allowed
Right,
under SB 824?
fair enough. That word's not in the law, but what House Bill 589 did and what Senate Bill 824 has preserved, as I said earlier, is the opportunity for political parties at the county level to appoint at-large election monitors who may go to any precinct they wish to challenge any voter. That's different from being limited to the precinct in which you and the voter are registered. And a provision for up to 100 at-large election monitors statewide who have the liberty to go everywhere they might want to go to pose a challenge to electors.
And what do you point to for the proposition that these individuals would be able to challenge a reasonable impediment ballot?
The legitimacy of that claim.
Which would then be, well, you say the legitimacy of the claim. What I'm asking is what provision of law empowers them to challenge a reasonable impediment form?
I don't know that the law specifies that.
Then where are you getting it from?
But it's one of many. I mean, it's of the general grounds that, to challenge a person's truthfulness in making that attestation.
What I'm saying is, where in law are you pointing to that would give these monitors the authority, the standing to challenge a reasonable impediment form as being false?
That is not specified in the law.
Okay, so then where are you getting it from if it's not in the law?
What do challengers do? They challenge an elector's honesty and forthrightness in presenting themselves to vote.
Now let's go back to the 1890s. These changes produced momentous results in the 1896 election, where turnout among registered Black voters rose from 60 to nearly 90%, correct?
That's correct.
Now, in the 1960s, North Carolina did not experience the widespread violence that beset the Deep South. Is that right?
That's true.
And in 1960, North Carolina elected a governor who was a moderate Democrat, Terry Sanford, who preached a message of opportunity for all and used the police power of the state to surveil and restrain the Klan. Is that right?
That's true.
And in the primary, Governor Sanford defeated someone who was a proponent of Jim Crow. Is that right?
That's correct.
And the primary voters chose Mr. Sanford. Is that right?
That's at a second primary, yes.
By the turn of the 1980s, African Americans were making significant headway in political strength in the state. Is that right?
That's true.
Harvey Gantt won the Democratic senatorial nomination in North Carolina in 1990. Is that right?
He did.
And he was the first African American Democrat in the nation to run for a U.S. Senate seat. Is that right?
I think you're right. I'll take your word for that.
Okay. And by 1989, there were 19 African Americans in the General Assembly, more than ever before. Is that right?
Correct.
And by 1991, and you referenced this in your direct, the office of the Speaker of the House was held by Representative Dan Blue, an African American, right?
That's correct.
And today there are 35 members of the House of Representatives that are African American. Is that right?
That's correct.
And so we don't see a pattern of backlash to having an African American speaker with 19 members in his caucus. We see a linear growth to 35. Doesn't that shatter the pattern that you've alleged?
No, actually, I think you've made my point. It is after that kind of growth, that is exactly where, from a historical perspective, I would expect the kind of response and intervention I've been describing. Those are exactly the circumstances that I described earlier.
Where was the backlash to having an African-American Speaker of the House? When did it occur?
The Speaker of the House, I don't know that there was a backlash to that.
When was the backlash to the 19 members of the House of Representatives, which was a high watermark?
Yeah, so we can go through these one by one, but again, my point is that there is an accumulation through the 1990s and early 2000s of increased minority political participation at the polls and in the halls of government. Was there a backlash against this particular official's election or that one? We could go through that for a long time, but I think the pattern holds. It is that cumulative increase in political participation, and the response is exactly as it had been in similar circumstances in the past.
You said in direct that the backlash was, quote, in short order. But here, you can't identify anything in over a decade after the gains of the late 80s as a backlash, can you?
Well, maybe those words mean something different to a historian. I mean, if we go back to the era of Reconstruction, disenfranchisement came at the end of a 35-year struggle. I don't think anyone would deny that the two are connected. And these changes over time in the legislature, they're relatively slow and incremental, but they have added up to something significant by the early 2000s. Not just this or that extra official at the local level, not simply the number of lawmakers in the legislature, but enormous increases in Black political participation across the board.
By 2001, in fact, 22% of the governor's appointees to state agencies and commissions were minorities, which matched the state's demographics. Is that right?
That's right. And again, that is precisely my point. That is another indicator of this growing minority representation and participation.
And between 1992 and 2009, Democratic lawmakers worked to sustain these achievements by expanding minority citizens' access to the franchise. Is that right?
They did indeed.
And many of their reforms echoed the fusion election of 1895. Is that right?
Some of them, in a broad sense. In a direct sense, yeah.
Many of them.
Again, echoed in a broad sense.
And
there wasn't provision for out of precinct voting in 1895, but as a general proposition that both these bodies of law increased representation, yes, that's a fair statement.
key legislation created an opportunity for early voting, allowed voters who went to the wrong precinct to cast a provisional ballot. Why was casting a provisional ballot for going to the wrong precinct something that was beneficial?
Lots of people are mistaken about their precinct. The analog in 1895 was a provision for counting a ballot that went into the wrong election box.
And so by allowing the provisional ballot, that increased the likelihood that those people's votes would count?
Yes, certainly.
Okay, and that's an ameliorative provision, is that right?
Yes.
Okay. And also we saw same-day registration, early voting between 1992 and 2009. That was implemented, correct?
That's correct.
And these reforms are still in place today, is that right?
They are still in place today only because of judicial intervention. House Bill 589 attempted to remove them, except for early voting. That was shortened but not removed.
And early voting is used disproportionately by African Americans?
It is.
Okay. In 1996, North Carolina ranked 43rd among states for voter turnout and rose to 11th place by 2012. Is that right?
Yes.
And in 2008 and 2012, African Americans registered and voted at higher rates than whites for the first time in North Carolina history. Is that right?
That's true.
And that was true, notwithstanding the higher poverty among African Americans that you described earlier, right?
Notwithstanding the higher poverty and without the barriers that we were discussing earlier in place.
So that's a yes. Notwithstanding the higher levels of poverty among African American voters, they were able to vote at higher percentages than white voters, right?
You know, I don't think that's a simple yes, no question, because in terms of analyzing this broad history, it exempts a very important part of the story. Yes, notwithstanding poverty, but also without poverty-related barriers being in place. I think it's certainly fair to conjecture that if those barriers had been in place in that era, we would not have seen the same kind of increase in minority political participation.
Well, in terms of one of the things you talked about differential impact of poverty rates was lack of transportation. That was true in 2008 and 2012, right?
Yes.
And African American voters were able to overcome those challenges and vote at greater rates than whites, correct?
Yes.
Okay.
That's on election day. That again exempts the entire process of acquiring a photo ID. That is an additional hurdle that was not there in the 90s and early 2000s.
They were able in the early 2000s to overcome the burden of having to register, and they were able to overcome the burden of voting, notwithstanding the lower poverty rates, right?
Again, I think a yes or no answer to that profoundly misunderstands the history and the relation of the history to the present day.
You've said a couple of times that 824 preserves aspects of 589. Do you recall that?
That's true.
But 589 was invalidated, right?
Not entirely.
Okay, so but then did 824 go in and reenact, repromulgate provisions of 589 that weren't struck down?
Somebody put the same words in the two pieces of legislation.
Well, let's start with the origins. The origins of 824 are a constitutional amendment, right?
Well, the origins of 824, I would say the origins are in the movement for ratification of a constitutional amendment.
But if we're looking for the but-for cause of why did the legislature pass SB 824, it was because there was a constitutional amendment which required them to implement legislation, correct?
That's true.
And that command to the legislature said that they may include exceptions, right?
Yes.
And did any of the past discriminatory laws in North Carolina have provisions that allowed African Americans to vote even if they did not comply with the requirements of that law?
A very small number would have passed the literacy test because they would have had grandfathers or great-grandfathers who have been allowed to vote before the constitutional change of 1835, but otherwise, no.
Okay. Now, by its terms, SB 824 applies to everyone. Is that right?
Yes, that's true. It doesn't mention race.
Okay.
Have I frozen here? Look, I'm not moving in my screen. Can you still hear me?
We can't see you. I can't see you anyway, but I can hear you.
Let me toggle the camera on and off just to see what's
Sure.
going on here.
And I see it's 12:30. I'm happy to press on, but I'm also sort of at a natural stopping point, whatever the court's pleasure is.
I was just about to interject. Thank you. I do think it's a good time to go ahead and stop for lunch, and we did lose Dr. Lutus's face there. We're going to go ahead and take our lunch recess at this point. Maybe when we come back from lunch, he'll be back such that we can see him. I wanted to remind the lawyers of I've just noticed as we've gone through some of the evidence and presented exhibits and shown those by sharing the screen. Sometimes those exhibits are referred to by name, but they're not always referred to by number and name. And so if you were in a courtroom, in order to make sure the record be clear, you would approach the witness. I'm showing you plaintiff's exhibit number 3, you know, and it also gives the court reporter reference so that anytime an exhibit is shown to a witness or to the court, the record later thereafter can reflect exactly which exhibit is being shown. So I would encourage the counsel to, when you put an exhibit up, if it has a number, if it's been admitted, then go ahead and put that on the record. I'm showing you exhibit JX45. This is your report. Look at page 76 with me if you would. You know, anything you want to do there, but just if you could reference those by number and name, it would probably be helpful later on for the record.
Yes, we're happy to do that. Thank you, Your Honor.
All right. Anything else before we break for lunch then?
Yes, Your Honor, and I apologize. I think there's some mowing outside of my window, so I'll try and speak up. I want to raise to the court's attention a scheduling issue that has arisen. We flagged this might be a possibility. Representative Pricey Harrison was scheduled to testify this afternoon. We had expected to be moving at a faster rate than we are, and we're advised that she has some legislative commitments this afternoon. So I expect we may need to pull her from the lineup this afternoon. Sabra Ferez is ready to go. And if we, depending on how long, if we go with Dr. Lutus and Ms. Ferez, we would have Daniel Smith ready to go after that.
Thank you. Do the defendants have any objection to switching that order?
No, Your Honor.
Okay, I think I heard from Mr. Thomas. I'm not sure I heard from Mr. Cox.
Might have spoken over each other, Your Honor. We have no objection.
Okay, that very well may be. All right, sounds fine, Ms. Riggs. Then just if you would make that change to the lineup, I think that'll work okay.
Thank you for your indulgences, Your Honor, and for everyone's collegiality.
Right. Is there anything else that we need to take up prior to breaking for lunch? Hearing nothing, then we'll go ahead and be in recess until 2 o'clock. Hope you all have a good lunch. We'll see you then.